Hello, good afternoon, Priscilla. We'll be starting the webinar by 3 p.m. So we're waiting for our speakers to join. We can officially start the webinar. Good afternoon, Mr. Seyi. Good afternoon, Mr. Seyi. Good afternoon, Mr. Seyi. Can you hear me? Hello? Mr. Seyi, please, can you hear me? Hello, good afternoon, everyone. I don't know if anyone can hear me. Please, if anyone can hear me, please can type on the chat box so I'll know that. Can anyone hear me? Okay, good afternoon, everyone. We'll be starting the webinar by 3 p.m. We're waiting for our speakers to join, then we can kick off the webinar. Thank you for joining us today. Okay, good afternoon, everyone. We'll be starting today's webinar. Our speakers will be joining us shortly. We already have Mr. Seyi on the call, so other speakers will be joining us shortly. Hello, everyone. Welcome to another exciting edition of the ESP Practical Lawyer webinar series. My name is Jessica Akinwunmi. I'm the moderator for today's webinar. At ESQ Training Limited, we provide comprehensive continuous professional learning with courses and training across various areas of practices. We have tagged this webinar series and launched our webinar series as it's slated to be held at 3 p.m. every Tuesdays and Thursday, respectively. After every section, we'll provide the resources in easily accessible format on a go for everyone who is interested. We'll be streaming live on YouTube and on Facebook. And today's topic is latest issues in corporate restructuring and insolvency. At the end of this webinar, the attendees will be able to understand the overview of corporate restructuring and insolvency, recent legal developments in corporate restructuring and insolvency, trends in corporate restructuring and insolvency. Please, if you do have any question while the webinar is going on, please do type on the Q&A or raise up your hand, and in due time it will be answered. It is a great pleasure to introduce our speakers for today, Mr. Kubi Udofia, who is a partner at Babalakin Co. LP, and he'll be speaking on overviews of corporate restructuring and insolvency. We have Mr. Seyi Akinwunmi, who is a partner at Akinwunmi Busari LP, and will be speaking on recent legal developments in corporate restructuring and insolvency. And we have Ms. Bisola, who is a company secretary and head of legal at Custodian Limited Trustees, and she'll be speaking on trends in corporate restructuring and insolvency. Please, if you do have any question while the webinar is going on, you can do type on the Q&A. And over to you, Mr. Kubi. Thank you so much.
Thank you, and good afternoon, everyone. And good afternoon, Mr. Akinwunmi. It's good to be here. So I guess I'll go straight to my presentation. I've been told that I have just 20 minutes, right?
Yes, sir.
All right. Okay. So I'll try to share my screen. Okay, so in the next 20 minutes, I'm going to speak on the topic and overview of company voluntary arrangement. So I'm going to give an overview of company voluntary arrangement. It's a very broad topic, one that one cannot do justice to in 20 minutes, but I'll try my best to highlight the very important areas of this very important restructuring tool. So my outline, first I'll give a brief introduction on the topic on what CVAs are. You'll be hearing a lot, hearing me say CVAs a lot because, I mean, CVAs, it means company voluntary arrangement. So then I'll briefly look at the procedure for approving CVAs under the Companies and Allied Matters Act 2020. I'll look at the contents of CVA proposals and remedies for aggrieved parties. And then in conclusion, I'll briefly look at the key advantages of CVAs. So by way of introduction, company voluntary arrangements are basically binding debt restructuring contracts or agreements. They are legally binding debt restructuring or composition between a company and its unsecured creditors. The key word is unsecured creditors. It has nothing to do with secured creditors unless they consent to whatever proposal is being made. So it's a debt restructuring plan, a contract between a company and its unsecured creditors. It could take different shapes and form: rescheduling of debt, deferral of payment, haircuts on the part of creditors. The options are basically limitless, and that's why it's a very flexible restructuring tool. I've given examples here. If you look at the screen to the right, you see lots of logos. Some of them we may be familiar with. These are very prominent companies that made use of CVAs to get out of their debt challenges. Some were successful, some weren't. Popular high street shops in England and Wales. So the CVA under CAMA is modeled after the UK regime, that of the UK under the UK Insolvency, English and Wales Insolvency Act 1986. So basically it's not a complete replica, but it's substantially modeled after what you have in the English and Wales legislation. So basically it entails a director where a company is not in liquidation or administration. It entails the director of a company making a proposal, a debt restructuring proposal or plan to unsecured creditors as to how to restructure debt, how to reschedule debt, how the company can get out of these financial problems. And at the end of the day, everybody will be happy, both the company itself and the unsecured creditors. If the company is in administration, then the administrator would be the one to make that proposal. If the company is in liquidation, then the liquidator would be the one to make that proposal. So it's basically supervised Well, initially, when a proposal is made, an insolvency practitioner would be the one in charge of convening the meeting of directors and a meeting of unsecured creditors to place this proposal before the company members, shareholders, and then unsecured creditors. That insolvency practitioner is usually known as the nominee. And once the terms of the proposal are approved, then the nominee will be known as the supervisor. So the supervisor implements the proposal, while a nominee is the one that would convene meetings of members, that's shareholders, and members meetings of creditors, and then place the proposal before them for approval. Of course, a unique feature of CVAs compared to administration and liquidation is that directors remain in control. This may have advantages. It also has some disadvantages, because it could be that the actions of the directors is what has led the company into its financial crisis. So, but in CVAs, they are allowed to remain in control. The nominee only supervises the process, while the supervisor supervises the implementation. They do not take control of the company. So insiders may find this procedure quite attractive because they will remain in control. There won't be any disruption of the operations of a company. So what about employees? Employees are usually in a very dicey position. So whether employees would remain with the company, or whether they will be redundant, or whether they will be sacked, would depend on the terms of the proposal and what the company itself or the directors and the nominee would seek to achieve. So in some cases, it may be necessary to lay off some employees in order to cut costs. I've made mention of the CVA of a company called Homebase. In the CVA of that company, the company had about 11,000 stores in the United Kingdom. It had to shut down about 1,500 stores. And that meant that some workers had to go. So about 42 stores were shut down, and 1,500 workers had to go out of 11,000 workers. So at least some jobs were saved, but some workers had to be sacrificed. So it is important to distinguish a CVA from schemes of arrangement, which we're all familiar with. Schemes of arrangement, which has been retained under, I think it's chapter 27 of the Companies and Allied Matters Act. There are many distinctive features between a CVA and schemes of arrangement under CAMA. One of them is that in CVA, the hallmark of CVA is that it is informal. It has limited court involvement or intervention. This is in contrast to arrangement where you go to court for court sanction, court ordered meetings, and all. Then in CVA, you do not have that difficulty of having to identify and get the approval of class of shareholders and class of creditors who will be affected by a scheme. In a scheme, one of the distinctive features of schemes of arrangement is identification of different classes that maybe will be affected by the schemes, and then getting the specific approvals, which is very critical to the success of schemes. In CVAs, that's not necessary. All what you need is the approval of shareholders as a group, no distinction, and then approval of creditors as a group. Then, as I highlighted before, CVAs bind only unsecured creditors. It cannot be made to bind or alter the rights of secured creditors without their consent. Also, it cannot alter the priority of preferential creditors. This is in contrast to schemes of arrangement, which can affect the rights of secured creditors and even holders of preferential claims. What one may consider a limitation of CVAs in Nigeria is that they are not backed by moratorium. So a moratorium is like a standstill arrangement that stops creditors from embarking on unilateral enforcement actions during the procedure. Schemes previously had no moratorium, but CAMA 2020 has provided moratorium for schemes of arrangement in appropriate cases where the office holder applies for same. In England, in contrast, small companies can apply for moratorium It helps to ensure that creditors, when the plan or proposal has not yet been approved, creditors do not embark on unilateral enforcement actions, which can frustrate the arrangement. So lastly, in CVAs, I've already explained that you have nominees. The nominees are the ones that start off the liaise with the company, and the directors in preparing the proposal, the plan, the terms, and laying same and convening meetings of meetings of shareholders, and then meetings of creditors, and laying this plan before them. And once it is approved, the supervisor takes over. Normally, the nominee transforms into a supervisor and takes over and supervises the implementation of the arrangement. In schemes, you do not have that. There's no need for insolvency practitioner and insolvency practitioner to play the role of a nominee or a supervisor. Companies clearly have that responsibility of carrying out any scheme or any plan that is to be implemented by way of scheme of arrangement. So, procedure for approving CVAs. I'm going to rush this because I think in the course of explaining some issues in the previous slides, I've gone through some of the procedures for approving CVAs. So how does this start? Basically, the directors, like I mentioned before, the directors of a company that is financially troubled would prepare a proposal. Most times it is done in collaboration with a nominee. A nominee has to be a qualified insolvency practitioner. So directors, after preparing the proposal, they'll deliver same to the nominee, who would look at same and then decide whether it is viable and whether the CVA is the proper and most appropriate way for the company to go in terms of its restructuring plan. So the nominee thereafter has 28 days after taking delivery or after being notified of the proposal to make a report to court. So he's going to submit a report and then submit the proposal which he himself and the directors have prepared to court. And in the proposal, he's going to indicate that he's going to state his opinion whether meetings should be summoned to consider the proposal. And if he's of the opinion that meetings should be summoned, he's also meant to indicate the date, the time, and the place for the meetings. That's the meetings of creditors and then the meetings of shareholders of the company. Of course, in the report, he's also meant to comment on the viability of the proposal, whether it's viable or not. So thereafter, I must highlight here that in this regard, because I'd stated before that in CVAs, there is limited court intervention. In the UK, what the court does here, the role of the court here is merely administrative. The court is not expected to sanction the report or sanction the proposal. In fact, some practitioners describe the court here as being a mere registry where the report and the proposals are lodged. So unless the court orders otherwise, CAMA 2020 provides that unless the court orders otherwise, the nominee would proceed to convene the meetings where a liquidator or administrator is in office and is the one preparing the proposal. Is not meant to make any submissions to court. He has the right to proceed or the powers to proceed to convene the meeting without submitting any proposal and report to the court. So the meetings, when convened, you have the meetings of creditors, which will be convened separately from the meetings of shareholders or members of the company. So the meetings, you have either of these three outcomes. It could approve the proposal as submitted by the nominee, it could modify it, or it could reject the proposal. But instructively, there are certain modifications or proposals that are not permissible. One of them is that there cannot be a proposal or modification for the CVA to come to an end, to cease. Also, there cannot be a modification or proposal for a CVA to affect the rights of secured creditors. I've emphasized this before, that CVAs have nothing to do with secured creditors. And thirdly, there cannot be a proposal or modification of this proposal to alter the priority rankings of holders of preferential claims. So a proposal will be approved where in a meeting where the decisions taken in a creditors meeting and that taken in the shareholders meeting are similar. Once they reach the same decision,
Hello, can anyone hear me?
I can hear you, but I think he
Okay, I think he's having internet issues. Let's give him a minute. He'll join
Yeah,
back
okay.
soon. Thank you.
all right. Okay.
Okay, good afternoon, everyone. He'll be joining shortly. I just called in now, so he'll be joining shortly. Sorry for any inconvenience this may have caused. Hello, Mr. Kubi.
Hello.
I think he's having.
Can you hear me?
Yes, I can. I can hear you. I think you have to do your presentation since Mr. Kubi is still having internet issues.
Okay. All right. I'll just try and share my content and see.
So he's already
Is it
on.
back?
Yes, he's back.
Okay. Okay, fantastic.
Thank you. Mr. Kubi, you can continue your presentation.
I'm so sorry. Let me try and share my screen again.
Okay, no problem.
And we're just getting to the most interesting part. You went off.
I'm so sorry.
It happens all the time.
I need the IT person to be on standby.
Yeah, no problems.
think you have to be on standby. Oh, wow, that's the wrong one. All right, so I'm back now. Sincere apologies for the glitch. I've actually gotten the IT person to sit right here with me, so I won't have. Okay, so I think the last line on this slide is that I'd highlighted this before. So once implementation starts, the supervisor would be the one to supervise the implementation. So basically, these are the contents of the CVA proposal. I won't go through them one after the other, but it's important to note that making false representation or acting fraudulently in order to obtain the approval of members and creditors in a CVA is an offense punishable 1 year imprisonment or a fine to be determined by the court. So there are key remedies. Of course, not every participant in a CVA may be happy about the outcome. So there are remedies for aggrieved parties. You have, it can be challenged on basically 2 grounds. Very limited grounds for challenge under CAMA 2020. First is unfair prejudice. So a creditor or a shareholder may complain that his right has been, his right has been unfairly prejudiced by the CVA. And under English law, they've kind of approached the issue of unfair prejudice in 2 ways. First, you have the horizontal prejudice and you have the vertical prejudice. It is something I hope that Nigeria would adopt this approach when we start having challenges to CVAs in Nigeria. So the horizontal prejudice basically has to do with the fact that the creditor or shareholder is complaining that he's been unfairly treated compared to the way that other creditors who are similarly, or shareholders who are similarly situated have been treated without any justification. We had this in the case of, in the Debenhams case, popular retailer, I'm sure most of us are familiar with this in the UK. The landlord complained that, he was being given, or it was being given part of what it was originally entitled to, while some suppliers were being paid 100%. Of course, the court dismissed this challenge on the basis that what the suppliers were being given was justified on the grounds of business continuity, because what the suppliers were being given was the prejudice has to do with a complaint by the creditor that if the company had adopted an alternative insolvency procedure, it would have been treated better. So let's say in liquidation, it would have gotten more than what he or she or it is being paid.
Okay, I think Mr. Kubi's internet is still having issues. Mr. Seyi.
Yeah, hello.
Okay, I think you can go on with your presentation. So
Okay.
I'll call him now. I'll go on with your presentation. Thank you.
All right, let me try and see if I can get it.
Hello, Mr. Kubi.
Yeah, I'm so sorry. Let me just round up. I'm so sorry.
No problem.
Yes, I have the IT guy right here, and I think he himself is helpless. So remedies upon successful challenge, revocation or suspension of a decision approving CVA. You could have an order by the court reconvening, meetings for a revised proposal to be made, or order for a reconsideration of the original proposal. So when a supervisor is implementing a CVA, what happens if there's a default? So a CVA is literally like a statutory contract. It's a contract. Once it's approved, it becomes. Can you hear me?
Yes, I can hear you, sir.
Yeah, once it's approved, it becomes a contract between the creditors, the shareholders, and the company. So if there's a default, the CVA may normally provides for what remedies will be available for parties in the event of a default. This could range from a revocation to termination. A revocation means that it would be assumed that the CVA never took place. I've cited the case of BHS CVA here, where the terms provided that if there's a revocation or a default, there will be a revocation of the CVA, and then the creditors will be deemed not to have made any concessions or waivers. They'll be placed in the position they were before the parties began negotiations. The supervisor may also take it upon himself, that's the insolvency practitioner, to petition for the liquidation of the company eventually. I think I'm on my last slide, which has to do with the key advantages. I'm not going to go through this one by one after the other because most of them are self-explanatory. I highlighted before, the directors remain in control. This has its pros and cons, but we're looking at advantages now. There is privacy, no need to inform the general public or to make publications that the company is undergoing restructuring, like you have in liquidation and administration. It's a very flexible restructuring tool. Anything can be done. Anything and everything can be done within the confines of the law. Reduction of companies that assist company in cutting costs does not require the company to be insolvent, like compulsory winding up. So the company can go into CVA when, in the eve of insolvency or before it even becomes insolvent. Company's operation not disrupted because directors are in control, management is not necessarily changed. It's relatively informal, less court intervention, unless there's a challenge, as explained in the previous slide. Of course, the debts are consolidated in most cases. So you have debts being consolidated and payments made in a lump sum to the supervisor, who now makes distributions to creditors. Less expensive than administration, simple and uncomplicated. It binds all unsecured creditors, whether they voted or not, whether they agreed or not, once the threshold is made. May promptly increase cash flow for the company, prevents filing of winding up petitions, because once a proposal is approved, it becomes binding on unsecured creditors. So nobody can embark on unilateral enforcement of rights. They cannot file for liquidation while the CVA is ongoing. And of course, no investigation of the conduct of directors. This is a bit controversial. I mean, directors have peace of mind to continue with their business. They're not distracted by petitions and all that. But it could also have a disadvantage in that directors who may have been culpable for the company going into the financial difficulty may walk away scot-free. Thank you very much, ladies and gentlemen, and my sincere apologies again for the glitches. Thank you.
Okay, thank you so much, sir. Okay, over to you, Mr. Seyi.
I'm trying to see if I can share my content.
Okay, sir.
Just 1 second. Although I'm not sir.
Sorry.
Let me just try. Connect. So there we go. Just 1 second, please. Second.
Okay, while Mr. Seyi is trying to share screen, if you have any question, please you can do type on the Q&A, and after everyone's presentation, the questions will be taken. Thank you so much.
I don't seem to be. I need my own. Probably need my own IT guy as well, but because those seem to be able to. I'm trying to get into my Google Drive. Anyway, in the meantime, while I'm trying that, I'll just go ahead and speak to what I have here. Is that fine?
Yes, you can send the slides to me so I can check if I can share it from my own end.
Okay, all right. I'll just send that to you.
Okay, so
1 second. I'll send it by WhatsApp. Is that fine? Or Bill?
yes, it's fine.
Okay, all right. Sent.
Okay.
So basically, what I would do is I've sort of gone through the entire gamut of what was said to me because it wasn't specified what exactly I should speak about. So I'll just speak since Kubi has done the CVA. I'll just touch briefly on the issue of administration. Touch on corporate restructuring as well, and then the administration. Essentially, as we all know, insolvency really is about where a company is finding difficult to pay its debts and run its business because of cash flow issues. So there are various interpretation or definitions of insolvency, but broken down, it's a company basically in trouble, financial trouble usually, and therefore there are various remedies to that problem depending on which jurisdiction you are. Some are more favored in one than another. In Nigeria, we have typically gone to we've typically gone the route of receivership or liquidations, and luckily for us, I'd say luckily because in my view, we have to give companies the opportunity to come back to life. You know, it's not once they gasp for breath that the company has to die. So even if it has a company financial distress, there must be an opportunity for it to come back to life.
Sorry, Mr. Seyi.
Yes.
Sorry, can you see my screen?
Yes, I can.
Okay.
Am I able to control? Only you can control it. Yes.
Yes, only me.
Oh yeah, because then I'll have to just sort of direct you because I'm going to jump various slides.
Okay.
Yeah, so I'll tell you what page I guess is the easiest way to go about it. Okay, so the first thing I'd like to do is go into page 16, corporate restructuring. Yeah. Yeah, I think that's it. So basically what I'll try to do is an overview of what corporate restructuring is. And I've said there is the reorganization of the company's operational structure, usually in response to its financial distress, for the purpose of stabilizing the company so that it can continue its business as going concern. A corporate restructuring can either be internal, that the company itself decides to do that, or somebody is appointed to do it for the company. Of course, it's usual and it makes sense for the first step to be internal. And it's when you can't do that, that you then try to move into the external one. Next slide, please. Yes. So in the previous comma that we had before, 2020, it didn't make adequate provision for corporate restructuring, which in some is called rescue of a company, because our insolvency network framework, as I told you earlier, lends towards liquidations or receiverships. So, and that usually led to the sale of the assets and all of that. And the company was either sort of completely dissolved or the receiver takes over. And in very few cases, there's some left to give back to the directors and shareholders. But most of the time, a receivership or liquidation, as the latter already implies, is usually towards the death of the company. Not all the time, because the receiverships or the receiver managers who run companies and don't necessarily mean the death of the company. But in terms of corporate restructuring, there usually isn't that much that's happened on the 2004 CAMA, because in our jurisdiction, the banks didn't really have the concept of putting good money, not in inverted commas, after bad. They felt that, get my debt repaid and move on. Although there are various things that were provided in that cover, schemes of arrangement and compromise, which offered a broad framework for rescue of failing companies, schemes of arrangements, and all of that. And it was there. But in truth, how much did we use them and how easy was it to use them was the question in everybody's lips. So we had a few of them. Considering the number of insolvency we had, there were very few of these schemes and compromise arrangements that we use. Next slide, please. So the efficiency of these schemes under CAMA was affected by SEC. For example, in one part of the law says for you to approve this, there must be 90% of the shareholders must approve for it to operate. Whereas under the Companies Act, there's 75%. There are various other little bits and pieces where there was distortion in the understanding of what really needed to be done. And that made it a bit difficult for many of the schemes, the PLCs in particular, for them to work. So we really needed to move away from the lip service being paid to corporate restructuring in Nigeria to a regime where we actually wanted it to happen a lot more. Next slide. Now, so on comes CAMA 2020, and where the drafters of that law looked at the global best practices and introduced various mechanisms for a business rescue concept, a business rescue regime for our laws. And the rationale behind a business rescue is to preserve the status quo of the company while the way forward is negotiated for implementation of that rescue. This rescue mechanism substitutes the endless contest to seize the assets of the debtor company once it's insolvent. The receiver goes in and takes takes over the company, and sometimes the company's directors fight back. But it's a system that gives the debtor an opportunity to reorganize its affairs. It identifies the need to preserve the going concern alongside maximizing returns for the creditors. So now the 2020 Act understands that it's possible for this company to be in debt and be in distress. But it's also possible for us to turn that around if we give enough time and look at the possibilities that existed or that exist to allow a win-win situation. So the company itself gets back on its feet. Sometimes it may be a leaner, a slimmer, a smaller business, cropped off of the excesses, but it also gives the opportunity for the creditor to get its returns, its debts repaid. So the law now protects the interests of both the debtor and creditor, as opposed to what we had before, where it was solely or essentially for the creditor only. Next slide, please. So the previous corporate restructuring framework analyzes internal and external mechanism as I've listed out there: arrangement and compromise, arrangement and sale, buyout, merger and acquisition, takeover, purchase and assumption. Next slide. But the newcomer introduces new provisions that promotes ease of doing business and reduces regulatory hurdles. And we've gotten some commendation on this. So the new act introduces a framework of rescuing a company in distress to keep it alive, as I said earlier, and provisions were made with CVAs, which Kubi has already spoken about, administration and netting. So I will talk about administration. It's the next slide. Now, chapter 18 of CAMA actually deals with administration. And this is a new introduction into the body of company law. And administration is a process that involves the appointment of an administrator to manage the company's assets with a view to rescuing the whole or part of the company's undertaking as a going concern. And I think this is premised upon that old saying that, the company is gasping for breath, doesn't mean you should bury it. You can give it a chance to have breath. So I think that's the idea behind chapter 18. It is an alternative to winding up, certainly, and it provides the possibility of thriving after surviving financial troubles. So section 444 of CAMA actually talks a lot about that, and that I would commend us with. The entire chapter 18 will give us better insights into what it talks about. So it tells us what the objective is in section 444. Next slide, please. Now, it also provides that if the appointment administrator takes effect, no legal action may be instituted against the company or continued against the company, except with the permission of the High Court or the consent of the administrator. Now, this is very crucial because there was always a need for a moratorium in cases where it was best for the company to, be able to do what it needed to do to save the company in terms of maybe reducing its size, letting go of some excess staff, all in a bid to pay off its debt. And this is not new in our company law, where you have other types, liquidations, receiverships. There's that stay as well. But what this does is that it recognizes that administration is key to this new regime. And therefore, you can't go while I'm trying to administer the company so that it can pay its debts, you go and file an action against it and get judgment and levy execution. So this section 480 gives teeth to the appointment of an administrator. It is mainly to protect the company from enforcement proceedings and legal actions, which might lead to winding up the company, thereby enabling the focus on what he has to do. Because if on one hand is defend an action and there's a winding up, how then can that administrator do the work that is been appointed or she's been appointed to do? Next slide, please. So what's the purpose? Rescue the company, maybe in whole or in part, achieving a better result for the company's creditors as a whole than if you were wound up without first being arbitration. For example, you have a company and you just go into liquidation. You sell the assets as is, recover. But in some cases, there is even no assets. All you do is you try and recover debts and then pay off. But if you had a situation where the administrator could create more value from what's found on ground, so that when the liquidation kicks in, then the amount that can be recovered for the creditors is even more. That way, you'd have taken benefit of the administrator. C is realizing property in order to make a distribution to one or more secured or preferential creditors. So the administrator goes in there to recover property or debts, whatever it is, and makes that distribution, which is at a better level than they may have done if they just tried to wind up. Next slide, please. 443 says how a person may be appointed as by an order of courts, by a holder of floating charge, by the company itself, or its directors under Section 459 of the Act. And that is actually was a very strange one to me. I happened to be in the UK many years ago when administration started, and I was involved in an insolvency matter. And I went to the company to see this administrator. And I saw the administrator in this big room, this big office. And on the other side of the room, on the other table, was the erstwhile managing director of the company. And coming from a jurisdiction where the receiver goes in, drives everybody out and takes over, it was a very strange thing to me. But they cooperated in getting the company from the doldrums where it was at that time to a place where it was continuing in its business, yet being able to pay off its debts, at least most of its debts. That debt in particular was compromised, but it could pay off all the compromised debts. And it's important to note that an administrator in the office of the court, whether or not he is appointed by the court. Next slide, please. Where an administrator is appointed out of court, if it has a cross-border element, an application must be made ex parte to the court for approval. And what's called an extra courier administrator appointed by a holder of a floating charge may, in addition to notice to courts, also requests in an accompanying ex parte application a formal court order. So if a floating charge holder appoints administrator, then he may apply to court as well in an accompanying ex parte application to get a formal court order. A person may be appointed administrator of the company only if he's qualified to act as an IP in relation to the company. I think that goes without saying, especially in the regime we have now, where everybody has to file and at the CAC anyway. So that goes without saying. Next slide, please. And I'll soon be through. I just thought I'd go through the administrator appointment and stuff so that we understand clearly where we are now, as opposed to where we were in the old regime. So a court may make an administration order in relation to a company where it's satisfied that it's likely or is likely to become unable to pay its debts, and the order is likely to achieve the purpose of administration, which we've already referred to. The purpose, of course, is to give it opportunity to turn around and be able to pay off its debts. And I've listed out there all those who can make an application for an administration order, companies, directors, and so on and so forth. And a curious one there is that a liquidator can make an application for an administration order. Now, the question that would ordinarily come to mind is that if the liquidator has been appointed to liquidate the company, is the appointment of an administrator not the exact opposite of that? Because the administrator is there to keep it alive so that it can get more value. And the liquidator is to, wind it up. Doesn't that seem to be a contradiction? And I'd say no. And the reason probably why this has come into play is because the liquidator's job, yes, is to wind up the company for the benefit of the creditors. And that's key, for the benefit of the creditors and the best benefit of the creditors. So if the liquidator sees that an administrator may bring more value in what will be into the insolvency estates, then it would be a good idea to appoint an administrator, and then that administrator bring value, and the estates can then distribute better value to the creditors. Next slide, please. And then I'll just sort of end this show. I'm just here because I think I'm running out of time anyway. The courts may make an administration order. So I think there's a next slide. Two more slides of this.
I think that's the last slide.
Oh, I see. Okay, I have one. I'll just read this. I don't know what happened. So without prejudice to the specific terms of the instrument creating a charge, any contrary or conflicting provision of the Act, the appointment of a receiver manager by a floating charge holder is to all intents and purposes equivalent to the appointment of an administrator. And the provisions of this part are applicable to the person qualified to act as an IP and appointed under the relevant instrument by the holder of the floating charge. And that's section 4544. Now, the reason why that is extremely important is this tells us that the regime of the administrator is here. So it doesn't matter that they're in the debenture, it says you can appoint a receiver. It does not stop you or stop us from appointing an administrator. The appointment of a receiver by the holder of a floating charge is to all intents and purposes equivalent to the appointment of an administrator. So it's clear now that where we have the opportunity to appoint a receiver, or the option to appoint a receiver, we can take the opportunity we have given to us by the newcomer to appoint an administrator for the reasons, for the purpose that I already have noted in the past few minutes. Thank you very much. I hope that I've sort of given a bit of clarity on administration and what it is. There's a lot more to understand, but if we read chapter 18 and put that next to what I put down, I'm sure that we'll have a better understanding, and we can advise our clients where appropriate to appoint an administrator rather than a receiver or a liquidator in the first instance. Thank you.
Thank you so much, Mr. Seyi. Our next speaker is Ms. Bisola. Over to you, Ms. Bisola. And please, if you do have any questions, you can do type on the Q&A, and after Ms. Bisola's presentation, it will be answered. Thank you.
Good afternoon. Standing on all existing protocols. Abisola Akinrin is my name once again. Giving honor to whom it's due. So when I saw the flyer and my the co-panelists, I began to wonder if I'll be in the right room. But it's fine. Okay, so I'll be sharing my slides now. Can you see my screen?
No, I can't.
Okay. One minute first. Okay, I think you have my slides with you. Would you please share? I have it right in front of me. I don't know why it's not.
Okay, let me do that now. You can start the presentation, so I'll just try to share this the slides.
Okay. Corporate restructuring. So I would like to say one of the old wigs, erudite wigs, once said that we have moved from the practice of the law to the business of the law. I guess my assignment this afternoon is to bring to life the concept of corporate restructuring and intertwine with insolvency. Really, I need my slides, really. Okay, so a company is said to be insolvent. Let me start by saying that organizational restructuring is something that should take place within a company fairly regularly. With our modern day economy being as dynamic as it is, and with the change being as prevalent as it is, companies need to be adaptive and flexible, and this requires regular restructuring. So it means having a proper diagnosis of what the issues are to help in situating appropriate solutions. So like the earlier speakers have said, in dimensioning what corporate insolvency.
So sorry, can you see my screen?
Yes, I can, thank you. Okay, next slide. So I credit that statement to, so insolvency has been defined in two ways, where a company's assets on the ways its liabilities, that is, liabilities are more than assets, or where a company is unable to fulfill its debt obligations. Next slide. I'll be as practical as I could be. I've been in-house for a while, and what we do mostly is transactions, so these transactions, I have interrogated or interacted with these transactions. So bringing them to life on this table. So corporate restructuring could either take the dimension of financial restructuring or organizational restructuring. Next slide, please. So the nexus, corporate restructuring can be the solution where you see any of these indicators to rescue an insolvent company, to prevent insolvency in the first place. The saying that goes, prevention is better than cure. I'm an advocate of preventive medicine. To prepare a company for the next phase of growth. We'll soon see that as we carry along with this presentation. And to prepare a company for investment. Next slide. So key indicators of insolvency, where you have low cash flow. Okay, so I must say at this junction that the three parameters with which you measure the performance or the health, the financial health of the company are the cash flow, profit or loss account, and the balance sheet. The balance sheet, typically depicts the assets and liabilities of the company. So where you have these issues or factors, there are key indicators of insolvency, where you have low cash flow, that speaks to liquidity, where you have future cash flow projections, low future cash flow projections, so where your total assets far on the ways your liabilities, where liabilities keep piling without corresponding or commensurate assets, and when there is decreased production, and then when there's poor revenue or contingency plans. So this offshoots of this could be spring up from poor financial management, lack of commercial expertise, not knowing business practices or the trends, excessive business spending, or taking extra debts, dependency on one client or customer. Next slide. So current trends in corporate restructuring. So typically, I would like to use two major sectors where we've had prominent restructuring activities, and more recently too. So I'll use insurance as an example. Is an industry that has been on the radar for a while. So corporate restructuring within insurance sector has been in response to NICOM's regulatory directives. I must say, in our culture, or in our client here, the culture has been that regulatory interventions have largely propelled corporate restructurings, and you soon see why. They've been catalysts to corporate restructurings. It's rare for you to see companies really, especially except they are in dire distress, to go into self restructuring, but the prominent or the giant industries within the financial services, regulators have had to intervene one way or the other to propel this restructuring activities or exercises. So prior to the 2019 recapitalization mandate, NICOM had in 2018 prescribed and compelled insurance operators to comply with the tier-based minimum solvency capital requirements. So at this juncture, I would like to say that the three major parameters for measuring the financial health of an insurance company are solvency margin, the asset cover, and the shareholders' funds, which speaks to liquidity, basically. So at that time, NICOM churned out the directives circular to say, okay, we're going to be measuring the financial health or the stability of our operators by their solvency margin, by how much their assets can cover their liabilities, by how much their assets can match their liabilities. So in response to this, and the essence, essentially, the CBMS was aimed at prescribing minimum solvency capital by categorizing insurance companies along the lines of the nature of their business, whether life, general, or composite, the size and scale in terms of balance sheet, and the complexities of risk underwritten by them. So in response to this, an insurance company embarked on capital reconstruction, balance sheet restructuring, and capital reduction through, next slide, please. Now, in response to this directive, an insurance company embarked on this to rejig its portfolio, its capital portfolio, by doing these three things. They use the utilization of funds in the share premium account to write off negative retained earnings. By negative retained earnings, I mean negative retained earnings. Retained earnings is profit. So when you're in the negative, is called negative retained earnings. So this company at that time had embarked on a private placement in 2008, issued about 20 billion shares at 50 kobo each, but at the market price of 2 naira each. It meant they had 150 kobo on each of those shares in the share premium. So like more than 3 times the actual value of the private placements exercise. They had it in share premium accounts, but they carried the funds for a very long time, because shortly after the recapitalization exercise, or shortly after the capital raise, the company plunged, the revenue plunged, and they could not declare losses by way of declaring dividends. So, and then the next issue to consider, the next step to take was to cancellation of shares issued but unpaid shares. So what the company did was, during the placement, it's offered or issued and paid for 14 billion out of the 20 billion shares, meaning 6 billion shares were unpaid for at the nominal price of 50 kobo, that's a market price of 3 billion naira. So the shares were housed with the intention, or with the belief that they will be issued at a future date in tranches. But the important thing was that they would be taken up, but they were never taken up, so they had to be cancelled. So this meant execution of share surrender, share surrender, deed of surrender by the holders of the warehouse of the shares. So the next thing was capital reduction. So this was considered under section 105 and 112 of 2004 CAMA, because the exercise took place in 2019, 2020. So the essence of that was to, maintain as lean as possible the capital structure in order to attract foreign investments or investments at all. We all do know that where there's a capital inflow, the ripple effect is share dilution. Okay, so they're saying, okay, let's just dilute ourselves, let's reduce ourselves to size, our actual size, so that we can attract investments, fresh inflow. Next slide. So, I mean, that's a typical example of an internal restructuring, which of course then later led to external, because there would be new investors joining the pool. So subsequently in 2019, also NICOM never went through the exercise, did not see the light of the day, the minimum solvency capital. So they introduced a recapitalization capital raise with a focus on shareholders' funds. This time around, shareholders' funds, using like 4 parameters. You can use your funds in your share premium account. You can have fresh inflow. You can have measures of acquisitions or spin off some of your assets. So, I mean, there was the recapitalization exercise or mandate was segmented, particularly during the COVID, in response to COVID, because seeing that insurance companies could not go to the market to source for funds, but operators have even sued NICOM. The case is the matter is still in court to determine whether this mandate would be enforced or not. So in response to that, companies have started taking steps. Next slide, please, to meet the recapitalization deadline. So, I mean, some companies were already in talks as to mergers and acquisitions, capital restructuring, like we saw in the case, the example I gave earlier, and then asset spin-off and divestment. A couple of them actually went into this, embarked on asset spin-off. Next slide. I'll elaborate more on the asset spin-off and divestments in subsequent slides. So another regulatory intervention was CBN during the bank consolidation in 2008. That was completed in 2008, when actual fact CBN churned out that circular or that directive in 2005. So this saw the trimming down of 138 money deposit banks into 24 banks, and more has sprung up since then. There are more mergers taking place. More mergers are taking place after then Access taking over Diamond Bank. The recent talks between Titan and Union Bank, the big Union Bank, I guess they have concluded that transaction, and yeah, the completion stages. Next slide. So more recently I'd just like to speak to the pension industry. PenCom recently increased the minimum capital of operators from 2 billion to 5 billion. So in response to that, some companies have looked inwards. Most pension companies anyway are private companies. They have looked inwards to say, okay, what do we have? Let's use what we have to get what we want, to achieve what we want or where we're supposed to be. So what I know some companies did was to capitalize their profits. So rather than declaring dividends, they plowed back their retained earnings into their capital. So they declared, issued scripts. So that, of course, that was also in response or in complying with Section 124 of CAMA 2020 and Regulation 13 of Regulation 13 of Companies Regulations. You know, so that's a form of restructuring or financial re-engineering, if you know what I mean. So in insurance industry, we saw a couple of an avalanche of spin-offs taking place. You know, so we saw ARM divestment of its life arm to Tangerine Life. Tangerine was new in time as of 2018, 2019. And then African Alliance divestment of a significant minority stakes in Pension Alliance into to an investor. AXA Mansard also divested its pension assets to Tangerine Group. So Tangerine now has the banking, the fintech, life, and pensions, all resulting from divestments. So, I mean, what happens at this stage is to see whether to prioritization of your assets. Say, okay, I'm bigger in the insurance space than the pension space. Let me consolidate my assets. So I either spin off or divest all or part of it, you know, to relinquish ownership, control, and management so that I can get some more funds. And this was just in response to the recapitalization mandates. Now it comes to capitalization mandates. So ICO also conducted plans for rights issue, issuing ordinary shares, you know, based on 5, then issuing 13 ordinary shares for 5 rights issue. The banking industry, CBN, takeover of Skybank, establishment of Polaris as the bridge bank, acquisition of 75 stake in Intercontinental by Access Bank, merger of Magnum, MBM, Trust, Merchants, Indo-Nigeria Merchants, and Trust Bank of Africa to become Sterling Bank. Subsequently, Sterling also merged with Victoria's Trust Bank and retained the brand Sterling Bank. More recently, Zenith also, in response to CAC circular or mandate to issue the bottom paid, to issue all shares in your capital portfolio, as recently passed members' resolution, you know, to issue all its unpaid shares. So to issue all unissued shares in compliance with Regulation 13 and Section 124 of CAMA 2020. So basically what I'm trying to say is that you look inwards to see what you have. So where internal mechanisms or internal coping mechanisms do not suffice, you know, to cater to that problem, then you can start looking at what's to mergers, acquisitions, and all. Next slide, please. So divestment and spin-off or spin-offs. Another viable tool that I know really works in this climate for restructuring is spin-off. Typically, an entity may consider divesting from another where major consideration is to consolidate, like the examples I gave earlier, where a business unit is no longer profitable or fulfilling its strategic purpose. So a typical example of this is UAC's spin-off of its majority stakes in its property business, UPDC, with the REITs. REITs is Real Estate Investment Trust Scheme to Custodian Investment PLC, who holds majority stakes as we speak. So you can also consider a spin-off if to reduce involvement in management, control over a business unit without entirely stepping away from it. Another response to regulatory intervention or regulatory directive was response was CBS directive to banks to divest from their core banking businesses. So this saw the emergence of the likes of FBN Holdings, you know, and GTCO more recently, and then increased valuation of an entity. So a notable insurance company is in the public space, spun off its pension assets, repurchased the pension assets through a share sale repurchase agreement in order to unlock the inherent value in the pension assets. So what this means is that the book value at that time was carrying a book value, meaning the cost value of the assets, that's the book value. So, I mean, according to NICOM regulations or guidelines, NICOM guidelines only recognize the cost value, that's the book value of assets, corporate assets, okay? So to unlock that, either you divest, you sell off, and plow back the proceeds into your capital, or, but you plow back the proceeds into your capital, which comes into your profit or loss account. I mean, of course, the ripple effect is to boost your shareholders' funds if you don't have any negative shareholders' funds. And if you do have, is to plug the gap and then build on it. So that's what a major an insurance company did. That's called financial re-engineering of some sort. Next slide, please. Oh, debt restructuring, interesting. My senior colleagues have dealt largely on debt restructuring, but I'd like to say one or two things. So some restructuring activities are underpinned by piling debt obligations. So, I mean, for insurance, liquidity is very key, solvency is very key. And so where your debt obligations far outweigh your assets or your liquidity, your cash flow, then there's a problem. So alternatively, a company may bank on voluntary winding up between a company and its creditors, particularly where the company believes it will return to profitability in the nearest future. I guess a jurisdiction or a case in question is the SIGA, Corporate Insolvency Governance Act of UK, that gave permanent solutions or offered permanent solutions and temporary solutions. One of such is came up with a new restructuring regime plan that binds creditors, making it fair and equitable. And I think Kama borrowed from that to say, okay, where a company is going through insolvency, an insolvent practitioner or administrator has been appointed, then creditors cannot embark on creditors winding up, except they get the permission of the courts. So another thing was a freestanding moratorium that's covered under section 443 and 549 of Kama, where a company is pursuing a rescue mission, no creditor can commence insolvency or winding up proceedings. Also, the ipso facto clauses, okay, it's asking suppliers to please honor supply contracts or obligations during dependency of them, during insolvency, during a period. I guess UK gave about a year or so. They started June 2020 and then up to August 2021 to say, okay, during this process, suppliers don't stop your supplies to companies so that they can come back to life. Next slide, please. Okay, some popular examples of debt restructuring. If you recall the AMCON BOI on-lending transaction that took place in 2010, that saw AMCON taking over the debt portfolio of banks to give them a breather, so that they could carry on, be liquid enough to make further advances and also cater to their depositors' requests in terms of withdrawals and all of that. So NICOM took over that. Then the Honeywell Group's divestment of majority stakes in all welfare mills, we don't know the political undertone or undertone to that. It was propelled or predicated on a debt restructuring on a debt obligation. Okay, so we also saw the rebranding of Etisalat to Nine Mobile in satisfaction of the syndicated loan of 1.2 billion granted by a consortium of 13 banks. So we saw Etisalat's EMTS, the UAE giant, selling its 40% stake, or I get to restructure the loan portfolio or liability of Etisalat. But to do that, there has to be some image laundering, hence the transition to Nine Mobile. And then HITV, very interesting, HITV relinquishment of its EPL, that's English Premier League license to DSTV. Initially had a monopoly, but where it could not meet the price for the license, the subscription of the license, had to, sell off to DSTV. Of course, that expired and DSTV took over. So HITV used the proceeds of that, to restructure its loan portfolio. Next slide. Now, legal restructuring. This is very interesting. More recently, we've had an avalanche of capital raises, terms as access to foreign direct investments, and the likes of Flutterwave, PayPal, Mizala comes to mind. So let me just give a brief illustration how this works. So next slide. So some of the rounds that have taken the shape of foreign direct investments, whether through Ps, that's private equities, or venture capitalists, or angel investors to start with. Those are seed rounds, or even at the formative stages of the company. So we have companies coming out issuing convertible promissory notes backed by a simple agreement for future equity. They've raised some companies that have raised equity through angel investors or venture capitalists. Some have, in the course of doing that, by issuing convertible promissory notes, have had to flip their shares. So what has happened is that a company that I know about was taken over. A company was established in Cayman Islands, that's a tax haven, and then bought over all the shares in a Nigerian company, an existing company, already, had carved a niche for itself in the fintech space, So what happened was they had to flip all the shares, 100%, to the Cayman Island company. So the Nigerian company then becomes a wholly owned subsidiary of the Cayman Island company with the same name. Next slide. So an entity can embark on restructuring to cut cost reduction. That's been on the lips of everybody now. Many whole companies that want to thrive and survive. So when a company is facing growing debts, it's likely that its running costs are too high. In these situations, within the corporate structure can highlight overspend, whether in the administration or operation of your business. So in order to reduce costs, it may consider liquidating redundant companies within the group to release assets, reducing the number of employees, or restructuring departments to move unnecessary management costs. So a case that comes to mind, an example that comes to mind is African Alliance Insurance embarking on members' voluntary winding up to liquidate its hairline business, which is Axiom Hair, its fast food business, French's Foods, and even its property business, a reality, to unlock whatever is only owned by African Alliance, 100% owned by African Alliance. So whatever the remnants is, going through the normal liquidation process, reverts to the shareholders after settling creditors and ranking in that order, in the order prescribed by CAMA. Next slide. So corporate restructuring can serve many purposes. We shouldn't run away from it. If we have proper diagnosis or prognosis, I guess the next step is to embark on a restructuring exercise that will bring the company back to profitability, survival, to thrive, to bring it afloat, to remain as a going concern, rather than letting it die. So many interests have to be considered. And typically, all of these things that you do put together is what is termed as restructuring. I guess that's the end of my presentation. Thank you. I'll be happy to entertain questions. Thank you. Hello?
Hello.
Hello, sorry. My system was having some issues. Sorry about that. Okay, I think we have a question, and it's from Mr. Kubi. Please, can you briefly discuss the difference between administration and CVA? Hello, can anyone hear me?
Yes.
Okay. Is Mr. Kubi on the... Okay, I think Mr. Kubi is not on. So, Mr. Seyi, could you
Okay.
please explain, briefly discuss the difference between administration and CVA?
Well, just generally, I think the easiest way to differentiate is by looking at their objectives. The administration is a procedure in which the IP is appointed to act as administrator, take control of the company, to bring it around, to recover it. And if the business is past that point, you may choose to sell it as a going concern, or indeed shut down the company altogether. The CVA, on the other hand, the objective is to preserve the business, to provide better returns to its creditors than in the case of an administration. Sorry about that. The business proposes an agreement to repay part or all of the money it owes to the creditors over a period of time. So in that case, the directors remain in charge of the company. So the objectives of the two is essentially where the differentiation is. In the administration, the administrator is in charge. In the CVA, the directors remain in control and continue to trade. I think that, in a nutshell, is what I think the explanation there is. But Kubi can help. I think it's back now.
Okay, thank you so much, Mr. Seyi. Mr. Kubi, would you like to say something? Someone is asking, can you briefly discuss the difference between administration and CVA?
Okay, hello. Thank you. So I think Mr. Akinwunmi has said literally all that needs to be said in terms of the distinction between the two processes or procedures. I mean, I didn't meet up, I didn't catch the beginning of his response, but I know he made the distinction between, in terms of control of the process, that in a CVA, the directors remain in control, just like I mentioned or highlighted in my presentation, while in administration, they will have to step aside while the administrator takes control. I mean, an administrator may decide to let the directors remain, but they would have to report to him. Whatever they do, they would have to get his consent. So the administrator is literally the one in charge. So that's a major distinction between a CVA and administration. Another major distinction is the issue of moratorium, which I also highlighted. It's like a standstill kind of arrangement. So once an administration begins, there's a moratorium which ensures that creditors, both secured and unsecured, cannot carry out enforcement actions. They cannot act unilaterally. So secured creditors cannot enforce their securities. Even owners of goods that are in possession of the companies cannot, or the company affected cannot repossess those goods. So if you have, if you're a judgment creditor, you cannot, complete your execution. But this moratorium does not apply. It doesn't apply when you have a CVA. In a CVA, I made mention of the fact that in the UK, you have what you call moratorium for small CVAs. So there's a provision for that for small CVAs. Or in Nigeria, whether it's a small, CVAs for a small company, whether it's a CVA for a small company, a normal company, the moratorium would not apply. So what is done for big companies or normal companies in the UK, what you usually have is that companies usually, in order to take advantage of the moratorium, that standstill arrangement that ensures that creditors do not frustrate the procedure. So companies would have CVAs in administration so that the CVA would take advantage of that moratorium that would come into effect when you have an administration in place. Another very significant distinction between a CVA and administration is the effect it has on creditors. I highlighted the fact that CVAs only affect unsecured creditors. The rights of secured creditors can only be affected or altered or tinkered with based on their consent. If you do not consent, proposals of CVA is only binding on unsecured creditors, but this is not the same with moratorium. Though one would argue that moratorium does not set out, with administration, one may argue that administration does not set out to redistribute rights among creditors in terms of stripping secured creditors of their security. But there are provisions when administrations are ongoing. There are provisions that empower the administrator to dispose of assets which are subject to either fixed charge or floating charge. Of course, there are also provisions which ensure that the rights of those creditors are protected, in that if the administrator deems it fit to dispose of assets which are subject to security, he must have to apply the proceeds from the disposal to take care of the debt obligations to those creditors. But you do not have this at all in CVAs. In CVAs, they have no business, trying to touch the rights or assets that are subject to secured creditors or the rights of secured creditors. So those are the major distinctions between, in addition to what Mr. Akinwunmi had stated, major distinctions or significant distinctions between CVAs and administration.
Okay, thank you so much, sir. Okay, we have another question. Can a receiver be appointed by the director of a company? And if so, will the creditors be able to appoint legally a receiver? Ms. Abisola, you can answer that. Then Mr. Kubi and Mr. Seyi can say something. Hello?
Hello?
Okay.
Is appointed by the court, I believe. Hello?
Hello, I can hear you.
Yes.
Should I repeat the question?
Okay, please do.
Okay, can a receiver be appointed by the directors of a company? And if so, will the creditors be able to appoint a receiver legally?
Receivership is another kettle of fish, but a receiver, to the best of my knowledge, is appointed by the court. Mr. Kubi and Mr. Akinwunmi can bail me out.
I think in the context of insolvency and security enforcement, a receiver can be appointed in court and out of court. So receivers are usually, it's a debt enforcement procedure, and they are appointed by certain secured creditors or debenture holders who have been authorized to do that by virtue of their, by virtue of a security agreement, holders of debenture. So they can be appointed. I'm not aware in the context of insolvency and security enforcement, I wouldn't know the circumstances in which a director would appoint a receiver, because it's a debt collection or debt enforcement or security realization process or procedure. So they are appointed by secured creditors or debenture holders. It can be done in court and it can be done outside court. I think Mr. Akinwunmi will speak more on this because he's an experienced insolvency practitioner. I'm sure he served as a receiver in the past.
Yeah, okay. Yes, thanks. Ordinarily, a director can't appoint a receiver the same way the company can't appoint a receiver against itself or by itself. But when the several directors are in disputes amongst themselves, one can go to court to ask the court to appoint a receiver over the company, just like shareholders can do. So I think that the answer to that question is no, but you can do it indirectly through the courts. But then you'll be a court-appointed receiver, not a director-appointed receiver, if that makes any sense. Because you can't. It's like Kubi just said, it's a debt recovery mechanism, and you can't appoint a debt recovery against yourself, unless, of course, that director happens to be, a secured creditor of the company. And there are circumstances where that could have happened, where maybe the director owns a company, disclose, of course, a transaction where they give a loan to the company and is secured. There'll be a lot of, there must be a lot of disclosure anyway, because I'm sure that in such circumstances, there will be many, many objections. But if you do have those secured credits, then the fact that a director doesn't make any difference. But ordinarily, the answer is a big no.
Okay, thank you so much. In the absence of no question, rounding off today's webinar, I want to say it has been an interactive and profound section today. Thank you to our speakers for joining us today, despite your busy schedule, and we look forward to having you in subsequent webinars. A very big thank you to our sponsors, LLP, Bluefield, the New Praxis, DOA, and Farm Resources. Thank you also to our attendees for participating in today's webinar. Please note that the next webinar will be on Thursday by 3 p.m. and the topic is Enterprise Risk Management. Lastly, please do subscribe to our YouTube channel at MyESP Legal to watch past webinars and more webinars. Do enjoy the rest of your day. Thank you so much, Mr. Seyi, Mr. Kubi, and Ms. Abisola for joining us today, and to our attendees.
You're welcome. I'd just like to say a big thank you to Kubi. Always a pleasure to be learning from you, and Abisola Akinrin. I need to come for some lectures on some parts of your presentation as well. Thank you very much.
Thank you,
Thank you,
sir.
sir.